contract law. Export sales contracts are central to international commercial transactions, and around it revolves a series of connected but distinct relationships including cargo, insurance, transportation, and payment arrangements. The rules and practices governing such contracts vary from one export transaction to another, based on the agreement of the parties as well as the legal system. National legal systems on contracts may differ, but the basic principles of contracts, such as good faith and consideration, are generally recognized and accepted in many countries. Certain differences in theory or approach are offset by countervailing force of international usage or custom, which brings about a predictable and harmonious outcome in commercial dispute resolution. It is pertinent to identify the motives behind the move toward harmonization of international contract law. 1. Increase in trade and other economic relations between nations. 2. The growth of international customary law. Commercial custom and usage have often been used in drafting and interpretation of commercial law. Today, certain customs and practices derived from merchants in Europe regarding documentary drafts, letters of credit, and so forth are universally accepted and form the basis for domestic and international commercial law. 3. The adoption of international conventions and rules. There have been several attempts at unification of international contract law. The most recent attempt at progressive harmonization of the law of international trade is undertaken by the United Nations Commission on International Trade Law. United Nations Commission on International Trade Law produced a set of uniform rules, CISG, on international trade that are a product of different national legal systems. Convention on International Sale of Goods, which came into force on January 1, 1988, governs the formation of international sales contracts and the rights and obligations of parties under these contracts. Many important trading nations such as France, Germany, Italy, the Netherlands, Singapore, and the United States have signed or ratified the convention. Applies to contracts for the commercial sale of goods between parties whose place of business is in different nations that have agreed to abide by the convention. Export sales contract. Oral contract statement. A contract need not be concluded in or evidenced in writing. Import companies that negotiate contracts by phone may be under the impression that the agreement will not be enforceable since it is not made in writing. Parole evidence. Prior oral statements, including witness testimony, are potentially enforceable and can be used to challenge the provisions of a written contract. The prior oral statement by the supplier is admissible and can be used to modify the terms of the written contract. The supplier would be obligated to pay the cost of insurance. Battle of Worms. A reply to a sales offer which purports to be an acceptance but contains additions or modifications is a rejection of the offer and constitutes a counter-offer. Duty to inspect and prior notice. In the event that the buyer receives non-conforming goods, he or she must give timely, within as short a period as impracticable, and effective notice of non-conformity, specify the nature of non-conformity. Rights to remedy deficiencies. The CISG permits the seller to remedy the delivery of defective goods after the time of performance has expired unless such delivery would cause the buyer unreasonable inconvenience and uncertainty. The buyer reserves the right to sue for damages caused by the delay or by the initial delivery of non-conforming goods. Exemptions from liability. The CISG exempts a party from liability for failure to perform any of his or her obligations due to reasons beyond his or her control and not foreseeable at the time of the contract formation. Prompt notice of the impediment is required to avoid damages. Limitation period. There are no provisions in the CISG on limitation period, the time within which a buyer must bring a court action or seek arbitration.
Pertinent clauses in export contracts. An export contract is an agreement between a seller and an overseas customer for the performance, financing, and other aspects of an export transaction. An export transaction is not just limited to the sale of final products in overseas markets, but extends to supply contracts for manufacture or production of the product within a given time period. Major clauses in export contract. Scope of work, including services, price and delivery terms, delivery, delay and penalties, quality, performance and liability limitations, taxes and duties, guarantees and bans, applicable law and dispute settlement. Number 1. Scope of work including services. The goods to be sold should be clearly spelled out in a contract. There is also need to include a scope of work to perform by the exporter, such as installation, training, and other services. The scope of work to be performed is usually contained in the technical specification, which should be incorporated into the main contract by listing it with other documents intended to form the contract. It is also important to specify whether the agreed price covers certain services such as packaging, special handling, or insurance. Number 2. Price and delivery terms. The total price could be started at the time of the contract with a price escalation clause that provides for increases in the price if certain events occur, such as provisions are commonly used with goods that are to be manufactured by the exporter over a certain period of time and when inflation is expected to affect material and labor costs. The following contract provisions would be helpful to the exporter. Shifting the risk to the overseas customer. An exporter may shift the risk by providing in the contract that payment is to be made in exporter's country and currency. This ensures protection against currency fluctuation and exchange controls. Payments in importer's currency. Even though the seller will generally prefer payment in US dollars, such a requirement may be difficult to comply with if US dollars are not readily available in the buyer's country. The exporter may have accept the payment in the importer's currency. Delivery, delay, and penalties. The most common type of clause included in export contract is one that provides for a fixed or approximate delivery date and that stipulates the circumstances under which the seller will be excused for delay in performance and even for complete inability to perform. The force majeure clause. Force majeure clause may also cover a number of specified events, including the inability of the exporter to obtain the necessary labor, material, information, or other support from the buyer to effect delivery. It should also include certain warranty obligations, such as delays in manufacture or of replacement components. It is important to state that the force majeure or excusable delay clause will apply even if any of the causes existed at the time of bidding, were present prior to signing the contract, or occurred after the seller performance of its obligations was delayed for other causes. Number 4. Quality, performance, and liability limitation. Most contracts state that the seller warrants to the buyer that the goods manufactured by the seller will be free from defects in material, workmanship, and and will be of the kind and quality described in the contract. Advisable to use certain approaches to limit risk exposure. Specify in the contract, stipulate the kinds of damages, limit the liability, carefully evaluate the costs. Taxes and duties. In the United States, Canada, and other developed countries, an exporter will not be subject to any taxes when products are exported to these countries, if business is not performed through an agent, a branch, or a subsidiary. However, when the price includes a breakdown for the installation and other services to be performed in the importing country, such income could be taxable as earning from services. Number 6. Guarantees and bans. It is quite common for overseas importers to require some form of guarantee or bond against the exporter's default. Public agencies in many countries are often prohibited from entering into major contracts without some form of bank guarantee or bond. Guarantees are more commonly used than bonds in most international contracts. In 1978, the International Chamber of Commerce adopted the Uniform Rules Contract Guarantees, which deals with guarantees, bonds, and other undertaking given on behalf of the seller and applies only if the guarantee or bond explicitly states the intentions of the parties to be governed by these rules. In view of the limited acceptance of the Uniform Rules for Contract Guarantees, the ICC adopted in 1992 the Uniform Rules for Demand Guarantees, which attempts to standardize existing guarantee practice. Number 7. Applicable law and dispute settlement. The fundamental principle of international contract law is that of the freedom of contract. This means that the parties are at liberty to agree between themselves as to what rules should govern their contract. Most contracts state the applicable law to be that of the exporter's country. This indicates the strong bargaining position of exporters and their clear preference to be governed by laws about which they are well informed.